Hi, I'm Tom Marks with the Marks Law Firm here in Orlando, Florida, and welcome to the Healthy Family Law Attorney. Because I believe your family matters, I want to provide hope and help to your family to successfully navigate the family law process in a healthy way. So today we're going to talk about the parenting plan. This arguably is the most important document in the entire family law case, whether it's divorce or paternity, dealing with the kids. Okay, this is going to determine how you parent the kids for the rest of their minority up to age 18 or until age 19 if they're still a full-time student in high school. So, and that deals with child support also. But in the parenting plan, we're going to talk about time sharing. And this is going to relate to my prior videos. I did a 4-part series on time sharing and the 20 factors that the court looks at in determining which parent gets what amount of time sharing and what goes into the parenting plan. So the parenting plan is critical for how the children are parented and all of your rights and responsibilities regarding the minor children. So we have 2 Supreme Court approved parenting plans in Florida. They're forms. One is the standard parenting plan that is used in the vast majority of cases, and the other one is known as a relocation or a long distance parenting plan. And I can get into that other plan in another video if anybody's interested, or if they know somebody who might be going through that situation, it might be helpful. You can forward this email, you can leave a comment, ask me to get into the long distance or the relocation parenting plan if you want me to. But for today's purposes, we're going to talk about the standard parenting plan. It's a form the Florida Supreme Court has promulgated for use in Florida. But I'm going to say right off that I think it's a great starting place, but it lacks a lot of detail. And my experience as a family law practitioner for almost 35 years here tells me that this is the place that most parents get into conflict with each other going forward in the future, because the parenting plan did not have enough detail in it. It left gaps for the parties to try to fill in later. And of course, they differ on what the meaning was, or if it didn't state with enough what we call specificity and particularity, then they're back in court. They're in disagreement. So let's dive in. Let's get into the details, and I'm hopeful that this will help you get through the parenting plan. Okay, so on the first page of the parenting plan, it's going to ask some basic questions. Is this a parenting plan entered into by agreement of the parties? Is it a parenting plan that only one of the parties is submitting? Or is it a parenting plan that the court has ordered that the parties abide by? All right, and then the parenting plan is going to ask, is this a final parenting plan, a temporary parenting plan, or a modification parenting plan? Obviously, the permanent one is at the end of the case. This is the parenting plan that's going to take you and your former spouse into the future, how to raise the children in the sense of what is the time sharing schedule, what is the communication going to be like, what is the who's going to have what holidays, what about the summer, what about extracurriculars. So there's all of that we're going to get into. If it's a temporary plan, then it's only going to be effective and enforceable during the case, and then you'll have to enter into a permanent plan at the end of the case. And a modification plan is if you already have a plan in place and now you're changing it because something wasn't working in the prior plan. Okay, on page 2 of the parenting plan, it starts out with the names, date of birth, and gender of the children. For name, you're not going to put in the full name. You want to protect the privacy of obviously your children, so you're going to put their initials in there. For date of birth, we're not going to put the full date of birth in there. You want to just put the year they were born. And you're not actually required to put in gender, but you can put male or female there. That's not a problem. Then you get into jurisdiction. You should just simply know there's nothing to fill in there. That's just the court telling you that Florida is going to be the place of jurisdiction unless the parties move or the children move out of state, and then you're going to have perhaps jurisdiction taken over by another state. The Uniform Child Custody Jurisdiction and Enforcement Act has a lot of detail in it, and it's beyond the scope of this video. If somebody would like me to get into the UCCJEA in the future, I'm happy to do that. Leave that comment, that request in the section below, and I'm happy to do that. So that's jurisdiction. It's also for the parental kidnapping statute and so forth. So you have to abide by the jurisdiction of the state of Florida and the laws of the state of Florida once this parenting plan is entered into or ordered by the circuit court judge in your family law case. Okay, so looking at Roman numeral 4 under parenting, we're going to start with either shared parental responsibility or on the next page, sole parental responsibility. The definition of shared parental responsibility is simply that the parents are going to have an equal say in all the major decisions affecting the welfare of the minor children. So that means education, medical, religion, maybe extracurriculars, significant things dealing with that. Okay, so interestingly, under shared parental responsibility, it has a section for who's going to make decisions regarding 3 areas there: education, medical, and religion. And you would think you'd just check mother and father. But this is actually an area where one of the parents can carve out, if they agree or if the court orders, specific areas, those 3 areas, where they will make the decisions and not the other parent. This can be done in the area of, say, medical, where one parent has shown no interest in going to medical appointments or the medical issues, or there may be special medical needs of one or more of the minor children. One parent may be especially educated or skilled or trained in that area. And it may be that the parents agree that, say, dad's a doctor, mom's a doctor, whatever, one's a nurse, and they want that parent to make the major decisions affecting the medicals regarding the minor children. Okay, education can be something similar. One parent is a teacher or a principal or something of that nature. I would say in the vast majority of cases, under shared parental responsibility, both parents will have an equal say in the major decisions in all areas: education, medical, religion, and so forth. Okay? On the next page, sole parental responsibility, that's where one parent's going to make all the decisions and the other parent's not going to make really any of the major decisions affecting the minor children. Now, I would say in this case, under shared parental responsibility and carving out those areas, we go into greater detail in our specific parenting plan, so it's very clear for the parties and the court. So if there's a later disagreement, there's no question who is supposed to make those decisions. Not that something was just checked in a box and maybe checked in error or something, but it's very clear. This is where I can't tell you how many times that a parent will come to me. They may have gone to a paralegal service, or they may have just gone online and found this form and filled it out and didn't get into any of the details like this. And then 6 months later, a year later, they're in conflict. They're having disputes over major areas of the parenting plan, and now that client, that parent is coming into my office and we're having to fix it. We're having to add more detail, and it can be very complicated and expensive to try to modify or change the parenting plan. Sometimes you're just clarifying it. That's a bit easier, but modifying requires a brand new supplemental petition to modify. And you want to avoid that. So you want to get it done right the first time. And that's why we're here. That's why we're trying to provide this information for you. And that's why the lawyers at the Marks Law Firm have this kind of experience and have dealt with these issues before. Okay, so let's look at the next page. Okay, so we've talked about sole parental responsibility on this page, and now we're talking about day-to-day decision making. Even if one parent has sole parental responsibility, doesn't mean the other parent isn't going to have overnight time sharing. Some people get confused with shared and sole parental responsibility versus time sharing or contact. Sole or shared parental responsibility is only dealing with decision-making regarding the welfare of the minor children. It's not regarding the actual contact time or overnights, time sharing, those things. So the parent the child is with is going to make those day-to-day decisions. What does the child eat? What is their bedtime? What is the regular discipline? What are their other schedules? So those day-to-day things are still available to the parent that doesn't have shared parenting responsibilities. Okay, next we hit extracurricular activities. Now, this is another place where I don't believe the form is sufficient. If you look at it, it has two boxes. One where either parent can register the child for extracurricular activities of the child's selection or choosing, and the other one where they both have to mutually agree. Well, the first one is problematic because what if the child wants to do 20 different extracurricular activities, maybe never finishes any of them, maybe they're very expensive like horseback riding or something like that. And so one parent can afford it and one parent can't. It may not be good for the child to be involved in so many extracurricular activities because they're struggling in school. So I'm not a real big fan of that first option. The second option is they have to mutually agree. Sometimes this is okay when the parents are getting along really well. Sometimes it's not okay because the parents really can't agree. There's a reason they're getting a divorce. They can't agree on the color of the sky. So you don't want to give one parent the veto of the other parent ever putting the children in an extracurricular activity. And I will say, even if you're agreeing okay at the time of the divorce, it may not continue. The only thing that I tell clients that I can pretty much guarantee for them is that things are going to change. And so what does that mean? Well, the children get older, they're going to get involved in different activities. The parents are going to meet a new significant other. There may be a new family, new other children involved in the mix. Your ex-spouse may want to try to meld their parenting plan into lining up with their new significant other's parenting plan, and it can just create a lot of difficulty. So it's really important how we detail and draft the details in these parenting plans. So one of the things I suggest is if the child or children are already involved in some extracurricular activities that you guys can agree on, the parents, then go ahead and agree that the child or children can continue with those specific extracurricular activities that you have detailed. You list what they are, so it's not subject to the court trying to figure out later what were you talking about. Or you may say that each parent may pick one or maybe two or up to three extracurricular activities per year that the children can be involved in, and either the parent picking the extracurricular activity pays for it 100%, so that kind of avoids one parent picking a super expensive extracurricular activity that the other parent has to be 50% financially responsible for. So there's a lot of nuances, a lot of detail that needs to go into this area. I see a lot of conflict that happens regarding extracurricular activities. So this is a place for you to really kind of camp out on and talk with in detail with your attorney about. You don't want to just check a box here. Not sufficient. You're going to be in conflict in the future. It's going to actually end up costing you more money trying to fix it later than doing it right in the first place in your original parenting plan. So also another issue that sometimes comes up regarding extracurriculars is one parent may be more cautious than the other parent. One parent may not want the minor children to play what they think are dangerous sports or get engaged in dangerous activities. This might, dangerous sports might include a parent's concerned about football, hockey, rugby, any type of contact sport like that. I've also seen cases where one parent might want to take the minor children on a motorcycle or engage in motocross, dirt bike activities, or believe it or not, skydiving, things like that. Don't know if that's going to be an issue in your case, but you may want to at least think about it and address it in the parenting plan up front to avoid an issue later on. Okay, looking down at the bottom of the page at Roman numeral 5, this is just information sharing. Both parents are able to obtain information from professionals, teachers, doctors, therapists, and so forth regarding the minor children. I think that's pretty standard. Most of those paragraphs are pretty self-explanatory. One parent's not responsible for getting documents like school records for the other parent. Both parents have equal access to those documents and can get them themselves. The last item under that category says that each parent has to keep the other parent apprised of any updated contact information or new residential address and so forth. I'll just add that that's a continuing obligation for either party or former spouse to advise the court of any changes in address, especially where there's like child support and the payments have to go through the registry of the court with an income withholding order. Okay, the next section talks about scheduling and the school calendar, and it's basically talking about communication between the parties. If you have a good time-sharing schedule, this is not going to be as important. For the time-sharing schedules that our law firm drafts, we do that on a calendar. It's very clear. One thing I will say is you really need to have start and end times very specific, meaning what time does one parent's time sharing begin, their start time, and when does it end? Okay, the parenting plan is also going to talk about what if there are changes in the time sharing schedule requested. That area, you can check some boxes, but I don't think it's sufficient. You need to put in more detail in this area. And the way it's drafted in the form, it's unclear if it's voluntary or required. I would say if you think on occasion, maybe 1, 2, or 3 times a year, you may need to adjust the time sharing schedule because something comes up and your former spouse is going to be very difficult about that. You want to draft in here that you have the right to do that. Obviously, it's going to be mutual, so your former spouse would have the right to make a limited number of requested time sharing schedule changes, but I would define how many. Is it once a year, once a quarter, or is it 3 times a year? That kind of thing. I wouldn't put in too many, because then the exceptions start to overcome or eat up the rule. So you want to know, and the kids want to know with some kind of certainty, what is the time sharing schedule and where are they going to be? So you want it to be very clear, but you also want to know if you're going to be able to make some schedule changes or exceptions to the time sharing schedule. Okay, so paragraph 7 of the parenting plan really gets into what is the time sharing schedule. I'm not a big fan of this part of the parenting plan because I don't think it gives you enough detail. I far prefer having it defined on the calendar which weekend. So if you're doing a week on, week off, when does it start? When does it end? Is it weeks 1 and 3? What about week 5? Because there's a couple of months every year that you're going to have 5 weeks, or a 5th week. If it's a 3-4, 4-3, meaning in week 1 you have 3 overnights, and in week 2 you have 4 overnights, so that it flips back and forth. So that's equal time sharing. There's a 2-2-3, which is 2 nights, then 3 nights. And I'm just going to say there are a myriad of time sharing schedules. I would caution against ones that require too much back and forth. The kids have to think, okay, where am I going to be tonight? Am I at mom's house? Am I at dad's house? It gets too convoluted. There's too much travel time for the kids back and forth. So the simpler, the better, in my opinion. But each family is unique. And so you're going to have to figure that out for your family. But talk through that with your attorney. I'm also going to say here at this spot, there is no form time sharing schedule for like pre-age or infant children versus school-age children, and their needs are really far different. So I would really recommend that you talk through that also with your attorney, because you can draft in a more limited time sharing schedule or less overnights away for an infant versus a toddler, preschool, school age child. So think about that, because this is going to impact you and the children for practically as far out as for the next 17, 18 years, depending on the age of your children. So let's get it done right the first time up front. All right. Okay, there is a provision in the parenting plan for different time sharing schedules for different children. I'm going to say courts typically don't like separating the children. I think most therapists would say it's not a good idea. It's not healthy for the children to have different time sharing schedules. The kids should be together, either at mom's house or dad's house, and not one child with dad and another child with mom, because that can create all kinds of problems, not just legally, but I think emotionally, familially for the children and the parties. Okay, so Roman numeral 7, subsection 2, we start with holiday contact with the children. So there are a lot of holidays listed on the parenting plan. You don't have to utilize every single holiday on there. It also has the children's birthdays at the bottom of the list. One thing that's not on there is the parents' birthdays and how you want to deal with that. So I would suggest that you address that at the bottom of that list where there's some blanks left. The parenting plan does give you the option of not alternating holidays and just following the regular time sharing schedule. That's rarely done. I think parents want to enjoy holiday time with the minor children. One thing I'll say is this is another area of conflict that I see. Somebody comes into my office, they already have a parenting plan. All they did was check. Even years, they get Thanksgiving. Odd years, their ex-spouse gets Thanksgiving. They don't really define what that means. Is Thanksgiving just the day? Is it just from 2 to 5 for dinner on Thanksgiving Day? Or is it the whole Thanksgiving break from school? And the parties are in total disagreement. One spouse says it's a 2-hour slot for dinner on Thanksgiving, and the other spouse says no, it's from the day they get out of school for the whole break until the day they go back, and of course then they're back in court. So you want to define these things again. Make sure it's crystal clear as best you can. You can't draft for every possible scenario, but with an experienced family law attorney, you can get a pretty good idea of all the areas where conflict typically arises. All right, let's look at the next section. Okay, so on the next page, we're going to look at paragraph 3, winter break, formerly known as Christmas break. This is where a lot of conflict arises. There's a lot of different ways to do this, and the most common way is to alternate, even in odd years, and break the Christmas or winter break into 2 halves, from the day the children get out of school until noon on Christmas Day, and from noon on Christmas Day until the children go back to school. And because it alternates, it evens out typically from year to year. The only problem is that, say, Christmas Eve may be super important to one parent and their family, and they would like to have Christmas Eve every year. Well, it's possible to do that. If the other parent's willing to do it and it's not important to the other parent, it can be drafted in there. This form is not sufficient the way it's set up, but if you have an attorney who has this on their word processor, can easily put in specific provisions. So it could provide that parent that wants Christmas Eve every year, defining what that is, and then maybe carving out another, like maybe New Year's Eve for the other parent, or some other night during the Christmas break for the other parent. All right, so typically the first half of Christmas break or the winter break is longer than the second half. Second half obviously doesn't give Christmas morning for the presents and everything, so that's typically done in the afternoon. There's ways to draft around that also. This is really, I find, an area of significant conflict. So really think this thing through. Again, understand that things are going to change. New relationships enter into the picture. The children get older. Younger children are more into Christmas. Maybe the older children want to do things with their friends. So think about these things. Talk to your attorney about them. All right, let's get to the next page. All right, so the next section talks about spring break. There are a lot of different ways to do this. You can alternate it, even year, odd year, the whole break, splitting the break in half. It really depends. Are you going to try to travel on spring break? You may not do that now, but you may do it in the future because of a new relationship. I'm more of a proponent of taking the whole spring break and alternating it, because if you break it in half, you really can't travel out of state, airfare, getting there, getting back, that kind of thing. That's another issue for Christmas too. If you split Christmas Day, nobody wants to be traveling and be in an airport on Christmas Day trying to get back in time for the other spouse. So think that issue through also, because I think it's really important. All right, next is summer break. Summer break is obviously the largest break of the year. Typically the school break is about 10 weeks. So you can either split it in half. One former spouse takes 5 weeks, the other spouse takes 5 weeks. However, most people say, well, I can't take that much time anyway. I'll take a 2-week or a 1-week vacation with the kids, and then we'll follow the regular time sharing schedule for the rest of the summer. All right, that's the way typically done, but not always. Now, it may be one parent believes that the children should be with him or her more during the school year because of homework and all that. And so they're willing to trade off some time in the summer so that they are with the kids, helping out, getting the schoolwork done and so forth, getting to and from activities and things like that. So the summer can be used as a trade-off to get more time during the school year. And so maybe give the other parent 7 or 8 weeks of the summer and then taking 2 weeks for yourself. Maybe not a great choice for some parents, but it is an option as a possibility for make-up time. The next section talks about transportation, and the first option is for one parent to do all the transporting. That's rarely done, but I do see it happen on occasion where one parent's concerned about their former spouse and say some substance abuse. Maybe the former spouse has had a DUI and the client says, I'm not comfortable with the kids getting in the car with them. I'll do the pickups and the drop-offs for the minor children for the time sharing for the other parent. I do see that. I can say that in those events, DUI or substance abuse issues, we do use something called SoberLink, where the other parent has to blow into a device which will send an immediate report to our client that says, hey, this is the blood alcohol level. It's clear. There's no alcohol in the system. And that may be written into this parenting plan. That's not provided for in the parenting plan. That's not in this form. So we can add those kinds of specific details for protections for the minor children and to help resolve disputes like that. Okay. But typically, the transportation is one parent does pickups, the other parent does drop-offs. I usually encourage the parents to do the pickup and drop-offs at school. So there's not a lot of interaction between the parents. One parent drops off at school, the other parent picks up from school, the parents don't see each other. It may be you're getting along really well. That would be great. That's best for the kids. Maybe you've done a collaborative case and we can do pickup and drop-offs from each other's homes. So that's an option also. Okay, the next section is going to talk about exchanges of the children and making sure they're ready, making sure they have all their clothing and items with them. I do see some issues with that where one parent feels like they're always sending the children over with new clothes, shoes, backpack, whatever, to the other parent's house. And when the kids come back, they're coming back in raggedy old clothes and they don't have their new clothes with them, and it's upsetting. So that can be drafted in here, but the form again doesn't get anywhere near that kind of detail. Also, the form does say that it has a blank for how long you have to wait for the other parent for the exchange. And I typically put in like 30 minutes and then you can go on and do whatever you need to do. You don't have to sit around for hours waiting for the other parent. There's a provision that sometimes we put in that says if you paid for a babysitter because you were going to go out and do something, let's say, and the other parent doesn't show up for their exchange, then that parent has to pay for the babysitter. Things like that. So there's a lot of detail, once again, that can be put in there. Okay, the next section talks about transportation costs. Typically, if both parties live local and there's no lengthy transportation, there's no airfare, that kind of thing, we leave this section such that each parent pays their own transportation costs. You don't want to get into the nitty-gritty of how much gas or mileage each of the parents is traveling if you're both local, living within 50 miles of the original residence, because if you move more than 50 miles, that's technically a relocation and you have to alert your spouse and the court and request the right to relocate. That's a whole nother video, a whole nother issue that we can get into at another time. Okay, so paragraph 4 now below is about out of state or out of country travel. I really find that first section to be a little bit ambiguous because it states either parent may travel with the children during his or her time sharing. It doesn't really get into what that travel is until later on. It talks about travel out of state. So I like to add more detail to this to make sure that it's clear that it's out of state. And the other thing I want to add is a lot of detail about what is the itinerary. A detailed itinerary to one parent isn't the same as the other. So how much detail do you want in the itinerary? Do you want the name of the hotel they're staying at? Do you want an address for it? Do you want a phone number for it? If they're going to stay at different houses or different parks or whatever, do you want the airline, the flight number, that kind of stuff? If it's not in there, there's a big question mark. Is that really required? You don't want to have to go back to court. You don't want to ask the judge to try to interpret that or impose something that may not already be in there. So that's another place where detail is important. Okay, so the out of country travel, the only blank there is for how much advance notice does that parent need to give you for when the travel is going to take place. I strongly recommend in this area that we put in some detail about where the travel is going to be. You want to make sure that the country that they're going to go to is a signator of the Hague Convention. That means that there's an international law on how you get the children back if that parent tries to keep the children in that foreign country. You know, all the European countries are Hague signatories, but Middle Eastern countries, many of them are not. So if your spouse is going to take the children back and go to Iran, Syria, something like that, that would be a problem. So you want to limit that. Also, it doesn't talk about who keeps the passport. I think that's really important. So there needs to be either you keep the passport or a third party keeps the passport, or there's some mechanism for it to be held in trust, pending travel plans and restrictions and all that being detailed itinerary, all of that being provided. Okay, so the next section on education is really important. It's asking which parent is going to be designated for the school district for the minor children. So does that mean elementary, middle school, high school? What if one parent lives in an area where the schools are very low rated schools, C or D schools, where one parent, the other parent is living in a school district for A-rated schools? You may want to consider that the children, you change this and you put in a provision that says, okay, the parties will reevaluate this on an annual basis, or when the children start attending elementary or start middle school or start high school, and the children will go to the higher rated school, and you need to define what that means. What is the higher rated school? And I think that's really important because you want them to go to a good school. Also, there's a provision for whether you're going to agree to private school or homeschool. You need to put in there detail about who's going to pay that, who's going to pay for uniforms, for books, for those kinds of things, because those expenses can add up. The next section is about communication between the parents and the children. Okay, so the next section is going to talk about communication between the parents. And it has a lot of different ways. It can be by phone, email, text, etc. Most parents can communicate well about the children, and of course I recommend that if at all possible it's a healthier way for the children and their development. But there are those cases, I do have those cases where my client gets literally physically sick after having to talk to the other parent. So they don't want to talk on the phone. They want to limit it to text, email, some other type of, there are apps, okay? There is something called Our Family Wizard, which I think is a good choice for situations like that where there's high conflict or problems with communication. We can talk about that app on another video, but it has kind of restrictions in it for language. It also makes it available for the court to look at it if there are problems that arise. So it kind of keeps the parties in check on how they communicate. On a high conflict case, I would recommend Our Family Wizard. Okay, so the next section talks about communication between the parent and the children. It has, you can choose any time or limit the time periods. Again, it depends on how well you're getting along, and is this privilege or right going to be abused? If it says any time, then I have some clients will come in and say, I can't have any uninterrupted time with the kids because my former spouse is always calling them when they're with me. So I want to limit it to, okay, from 5 to 7 at night, or after dinner from, say, 7 to 9 or whatever, depending on the age of the children. You don't want the former spouse calling the children after they've gone to bed or in the morning when you're trying to get out the door to get to school. So again, that's another area to really think about. Really important you're gonna have to deal with this situation until the kids are 18 or are out of the house. All right, the next section under childcare is another big conflict area that can arise. Do you have to mutually agree on child care providers? I recommend that if you have family in town, that you carve those people out. So your mother, father, brother, sister, if they're, decent people, can watch the kid. You don't have to have agreement of the other side. Maybe you have somebody already in place, you put their name in so that there doesn't have to be mutual agreement, so there's not a conflict going on there. On the flip side, you may want to have mutual agreement because your ex, I had one where they were dating an exotic dancer, and believe it or not, that person, she liked to walk around the house without much clothes on, and they had young children, young boys. So that was a big issue, and we had to deal with that. So again, it depends on the level of conflict and the level of maturity of you and your spouse, former spouse, how you deal with those issues. This is where we put in, it's not defined this way in the form, but it's called a right of first refusal. What if your former spouse has time sharing with kids, but cannot physically be present with them because he's got to go into work, he's got to go on a trip? Can your former spouse leave the children with a babysitter, with a girlfriend, with a new spouse? So you want to deal with that. There can be restrictions anywhere from they can't leave the children or where they're physically not present for more than 3 hours, maybe at the shortest, to maybe not overnight at the longer area time. So the question is, the answer is that your former spouse would have to call you and give you the right of first refusal that says, hey, I can't be with the kids, I've got to go into work, or I've got to take this trip. Do you want the right to come and get the kids, or I'll bring them to you so you can watch them rather than me leaving them with a sitter or with my mom or whatever, if you haven't provided for that. All right, so I hope that helps. I think that's a really important factor because I see a lot of conflict. I know judges really don't necessarily like right of first refusal. Well, strike that. I know judges don't really like rights of first refusal because they feel like it creates a situation where the former spouses are micromanaging each other. But I find that a lot of former spouses or clients that are in the process really want that protection in there because they want to have the children with them rather than the children being with someone else, some third party. Okay, so finally, the form parenting plan talks about modifying the parenting plan and how you do that. You should talk to your attorney about that. That's can be fairly involved how that is going to happen and what you'd have to show. It's much better to get the parenting plan in place the way you want it originally, much harder to modify it later. And finally, it talks about relocation, which again is a clearly defined process in the statute that you'd have to talk to your attorney about. If you have a thought that you might be relocating and you know that during the divorce, you should let your attorney know that so they can draft into the document, what if you relocate, what happens, rather than having to go back to court later and prove why you need to relocate and why you need this new time-sharing schedule. And the final thing is, what if you have disputes? Do you go back to mediation? Do you go into some other, what we call ADR, which is alternative dispute resolution process? Or do you dispense with that and be able to go right back into court? I'm a big believer in mediation and ADR. I just carve out typically that if it's a emergency issue or it's a contempt issue, then there's no requirement to go back to mediation. Otherwise, if it's something that can be resolved more easily and it's not someone subject to being sanctioned by the court because they're really doing something bad, then mediation or other settlement process, ADR, is an answer. So I know this video seems like it's been a little bit long. I know I wanted to provide a lot of detail here for you because I think the parenting plan is that important and I cannot overemphasize that. If this video you think it would be helpful for someone else to see, you can forward this to them. If you found it to be very helpful for you, I would love it if you hit that subscribe button or that like button or both. I'm posting new videos every Wednesday and new interviews every Friday. So I hope you have enjoyed this. I hope you continue to stay tuned to the channel, and I will see you next time. Thanks.